Good. All right, and we're back on the Ustream. Cool. So, all right. So going back here on page 2, Joseph Spencer's attorneys, Clifford H. Moore. Joseph Spencer's attorney Clifford H. Moore and Lawrence Weldon, also Europeans, filed a demurrer to Abraham Lincoln's declaration. Right. Later we'll talk about what a demurrer is, but it's basically a response to a plea. It's a type of response to a pleading that you would make in a court. But look that up. We'll talk about that later. Demurrer to Abraham Lincoln's declaration, asserting that his charges were insufficient in law. Right. And make a mental note, you guys. Federal Rules of Civil Procedure, Rule 12, B6. All right. And just write sufficiency of claim or insufficiency of claim, and just make a mental note right there, and we'll unpack that later in future classes, right? Judge Davis, and you guys remind me, who are most interested in it, but those who can't wait, go on and look it up. Agreed that 2 of Abraham Lincoln's 3 charges were faulty. The case was continued, and Abraham Lincoln was allowed to amend the declaration, right? And, we'll talk about pleadings and all of that good stuff later. But he amended his pleading. He fixed what they said he had wrong about it when they said it was insufficient. So he went back and fixed it based on the amendment of the pleading, right? And it said at the next term of court, October 1855, the Dungey case was argued before a jury, right? According to Joseph Spencer's attorney, Lawrence Weldon, Abraham Lincoln's talents as a trial lawyer were evident in his argument for William Dungey. Lawrence Weldon stated that Abraham Lincoln questioned Joseph Spencer's character by demonstrating how Joseph Spencer, went from house to house, quote, quote, gabbing that William Dungey was a, quote, quote, nigger. Attorney Lawrence Weldon emphasized that Abraham Lincoln's tone and pronunciation had, quote, a curious touch of the ludicrous, which instead of detracting seemed to add to the effect, end quote. Abraham Lincoln further undermined Joseph Spencer by using humor to persuade. Now, keep in mind and peep, right? For those who are the younger generation, peep the game, peep the science, right? Keep in mind how Lincoln is making these arguments and what social issues, right, he's making a point of attacking as he's making these arguments, right? Because these are going to be very important, and these are things that happen to this very day. If you ever watch court TV or you ever, sit in on a trial or anything, and you get a chance to actually hear the arguments from the attorneys, and if you're ever so lucky, whatever, to see a jury trial from the, from the gallery and not as a defendant, or a prosecutor, you'll be able to see some things in terms of style and how people operate, the strategy of the game, so to speak, and, really be able to appreciate what's going on and what we're talking about here, right? So I just want to keep, for those who got the eyes to see and the ears to hear, I don't want to give too much. For those who don't, whatever. Anyway, Abraham Lincoln further undermined Joseph Spencer by using humor to persuade the jury that there was reasonable doubt regarding William Dungey's race. The attorney, and you also want to keep in mind how other people will try to use these same tactics against you, right? The attorney, Lawrence Weldon, recalled Abraham Lincoln's statement, quote, "My client is not a Negro. Though it is a crime to be a Negro, no crime to be born with a black skin. But my client is not a Negro. His skin may not be as white as ours, but I say he is not a Negro. Though he may be a Moor," quote, Abraham Lincoln. Quote, "Mr. Lincoln," quote, interrupted Judge Davis, scarcely able to restrain a smile, quote, "You mean Moor, comma, not Moor, and that's Moor, M-O-O-R, comma, not M-O-O-R-E, and this, you know, how it's written, those of you in the classroom can see right here. This is where I'm at right here. Well, Your Honor, Moore, and this M-O-O-R, not Clifton H. Moore, M-O-O-R-E, right? End quote, replied Mr. Lincoln with a sweep of his long arm toward the table where Moore and I sat. Quote, I say my client may be a Moor, and this is spelled M-O-O-R, comma, but he is not a Negro, end quote. Abraham Lincoln, you know, that was the quote from Abraham Lincoln. It says, though the account may be apocryphal, Attorney Lawrence Weldon's recollection was characteristic of Abraham Lincoln's style. Abraham Lincoln then demolished the defendant's witness's testimony. Attorneys Clifton H. Moore and Lawrence Weldon had secured several depositions from residents in Giles County, Tennessee, the Dungey family home. These witnesses stated that they had personally known the family and that the white community had regarded the Dungeys as quote, quote, Negro or of quote, quote, mixed blood. Under cross-examination, Abraham Lincoln argued that the testimony was hearsay, pay attention, as the witnesses admitted none of them lived within 30 miles of the William Dungey residence. So they was going off of something that they heard, right? That's what made it hearsay. Just pay attention. You know, this is touching on, like I said, this is going to touch on a lot of concepts, whole lot of concepts that you need to be kept in mind. You know, with hearsay, just keep in mind the rules of evidence, right? And the standards of proof and the ability of hearsay to be brought in to the court as evidence, right? You know, can it happen? Can hearsay be used like that, right? And in some instances it can, in some instances it can't. But, you know, do your own studies, you'll see, and we may bring it out in other classes. But let's finish. On October 18th, 1855, the jury returned a verdict of guilty and granted William Dungey 600 notes in damages plus, oh shoot, it's 836, all right, in damages plus court costs of 137.50 cents notes. Abraham Lincoln charged a 25-note fee, which Lawrence Weldon considered minimal. To avoid an appeal to the Illinois State Supreme Court, Abraham Lincoln persuaded William Dungey to remit 400 notes of the judgment in return for the defendant releasing, quote, all errors which may exist in the court record, end quote. Under Illinois state law, the defendant could not appeal the verdict, but could appeal only on errors of procedure or evidence, right? Now keep in mind, depending on where you're at, and you know, if you're talking about an appeals process, you may not be able to appeal the verdict, right? Like the final judgment, the fact that they said that you're guilty or not guilty, you may not be able to appeal that per se, but you may be, if you were bringing up certain objections during trial, right, bringing out certain errors of procedure or evidence, like I was saying earlier, if certain things being brought into evidence weren't, you know, properly brought based on procedure or just based on the basic rules of evidence, you know, then there's an error in the trial, right, in the record for the trial. And you may be able to go back on appeal and argue those errors as the basis as to why the verdict was, you know, invalid, or though it may have been reached at a valid basis, that because of this, that it should be overturned, vacated, whatever, what have you, you know, whatever the argument is, right, that wins the day, so to speak. But pay attention to your local laws, right, or local, you know, rules, so to speak, for the court and all that good stuff, because not to say that they're overriding or that they're always the end all be all, but you just want to look to them, to measure them to the Constitution first, to see whether or not, you know, they meet that. Then if they meet that, then we worried about compliance. But it first has to match up with the Constitution, right? Logically, not just because you say it, you know, you or they, whoever mysterious they third party is, right? So under Illinois state law, the defendant could not appeal the verdict, but could appeal only on errors of procedure or evidence. Abraham Lincoln had taught Joseph Spencer an expensive lesson in domestic relations. All right, and that's saying it's coming from the Copyright Illinois Historic Preservation Agency, Springfield, Illinois, 1992. Note. So these are notes. The reader, and this is just to wrap up, the reader, researcher, or scholar is advised to review the foregoing synopsis of the William Dungey slander case in 1855 with keen consideration of the realities and facts that one's status also determines one's standing in relationship to one's estate. Thus, the spurious tags. This is getting right into what I was talking about earlier. The spurious tags, brands, and nom de guerre, right, or war names, quote, quote, black and quote, quote, Negro, being pejorative and quote, quote, status compromising nom de guerre or war names and misnomers can and will create serious and debilitating social and economic repercussions in relationship to William Dungey's estate, right? His property, his land, okay? Because if he, and I'm pausing right now for those who, who are looking at it and they want me to just keep on reading, I gotta say this. If William Dungey gets classified as a Negro and he just lets that hang out there and linger, he may be disinherited from his estate or disenfranchised from his estate based on that cheated, status that has a direct impact on his equitability as an heir, being Moorish or Al-Moroccan on his Al-Moroccan estate. Keep in mind the complexity of this relationship and the simplicity and how he can be removed from it just by ignoring these very salient, very basic details. All right? I really want y'all to pay attention to this because this is very, very, very important. It cannot be overemphasized enough. Right? Status and estate are one and the same. So getting back into the reading here. All right, that's just definition. So we'll go over these later. But getting into this last little part here for this paragraph. Such a damaged reputation will place all of his present and future, and this is what I'm saying. Such a damaged reputation. So him being classified as a Negro would put such a damage to his reputation that it will place all of his present and future hereditaments at risk and subject to its cheatment, right? By the state or by anybody else who has superior claim or title, right? Keep in mind that the European Roman colonial unum sanctum and the colonial quote unquote unum sanctum and the quote unquote doctrine of discovery policies are in effect at and upon the lands of aboriginal natural peoples of North America and the Western Hemisphere. Therefore, one must be aware of the past and thus of the present, right? So it goes on to define, we got status, estate, hereditaments, black, right? And we'll unpack this later because we're out of time, really, and I really want to get to some whatever questions you guys have. Islam, brother, so many layers. It really is. It's really a lot of layers to this case. Islam. So we'll open up the floor. Any if your audio is blocked, I'm unblocking you now. If your video if you want to turn your video on, you can turn it on. But we're gonna open up the floor for the last probably 20 minutes, 15 minutes, maybe 20 minutes or so, because we're really past time here. But it's been a minute since we've been here. So since I've been here, since we've been here in this digital space that we created, in our own world, being studious Moors. But I wanted to make sure that we cover some ground as we often need to do and should do, so that we'll be in a good space for next time. So with that being said, if there's no questions or comments from the people, type them up real quick if you got them. But I just got some last minute comments to kind of throw out there as y'all are coming to the floor with those. If you've been paying attention, Brother Nasir, you can step in whenever you're ready. But if you've been paying attention to what's been going on the past couple of weeks, in the past couple of months, we've been going into some transition here. From a corporate leadership standpoint, we're going from the Obama administration to the now quote-unquote Trump administration and realize that these administrations are corporate executive transitions. All right? Corporate executive transitions. They are these. This is the executive branch of government. All right? So, you know, when that's changing around, when that's happening, that doesn't mean that the people, right, or that when you're looking at Article 9, that the powers reserved in the people are going anywhere. Okay? None of that has changed. But what has to change and what will change is the manner in which business is done. Right? And that is all based on, you know, whatever customs you and I come up with or, you know, decide for ourselves in the here and now. So, so I want to read a couple of things, or one or two things, maybe just one thing, and then open, like I said, open the floor for last comments, and like we said, we'll just kind of talk our way out of here from there. So, prophet makes plea to the nation, right? And this is page 4 of the Moorish literature. You know, you can get a copy at rvbaypublications.com. You know, all that good stuff. Prophet makes plea to a nation, our divine and national movement. So the divine is a divine and national movement, not just the temples, you know, not just the study group or whatever, but divine and national movement. So our divine and national movement stands for the specific grand principles of love, truth, peace, freedom, and justice. And I, the prophet, am applying to all loyal, faithful Moors, members, and the American citizens to help me in my great uplifting acts of uplifting fallen humanity among the Asiatic race and nation. Right? For I have suffered much and severely in the past through misunderstanding of what the movement was dedicated to. It is the great God Allah alone that guides the destiny of the divine and national movement. Right? Not Tashri Bey, not Nunaji El, not Nasir, not Cujo, right? Nobody else alone guides the movement but the prophet and Allah. And that's why it says it is the great God, and I'm getting back into it, it is the great God Allah alone that guides the destiny of the divine and national movement. I know all true American citizens are identified by national descent names to answer and to apply to the free national constitution of this free national republic of the United States of America. Why? Dungey cannot apply the constitution of the U.S. as a Negro. Why? Because they had black laws that separated and disenfranchised him from being able to enforce the Constitution. Islam. So our national descent names, 5 of them mostly, Il, Al, Bey, Day, and Ali, right? These are the titles of the vast estate. These are the descent names. These are the family names that we take on as Moors, being active and not passive, right? To show our allegiance and to make markers, not just for ourselves, but for our families who will come later to see that we came, right? So that when we're doing business in our names, we're not doing business in a foreigner's name. And when we're establishing these trusts and we're putting these things into a more perfect conveyance, that conveyance will be clearly owned not by corporate property, but clearly owned by a living, breathing, sentient being, right? Who has the descent name that is associated with the land, with the estate that they are on. All right? The land being Al Morocco, Al Maghrib Al Aqsa. All right? Northwest Amexem, Northwest America, Northwest Africa. Okay? if you don't have that family descent name on paper, if you don't have it in your mind, how can you represent that? How can you present yourself as that? How can you be that in fact? Okay? And then if you are not that in fact, how can you demand respect of that honor, that title from another, if you yourself don't have that honor? Islam. So to finish the Prophet's plea, to kind of get off my soapbox and wind it up, and I know I'm getting into a rant, but it's like, come on, y'all. That is why, this is the Prophet talking, that is why I am calling on all true national citizens to help me morally and financially in my great work I am doing to help this national government. For without a free national name with a descent flag of your forefathers, there is not a national divine title of the government in which we live. So there is no national divine title of the government. So the government inherently is represented based on how the people are recognized, not the other way around. Okay? So it's when, and I say that because Moors, when we send out our writs and we're saying, oh, they didn't say nothing, there's no response. What response are you expecting from a de facto entity that does not exist, only put on paper? Okay? What kind of response are you looking for from a zombie? Other than the, what are you looking for? They're dead. Okay? So the insanity of thinking that you're going to get a response from a block of wood, people, is just that. It's insane. Okay? So this last part, this is from your true and divine prophet unto all American and foreign sympathizers. So he was talking to everybody. He was talking to the whole world when the prophet said that. All right? When you put your writs out there, understand that your notice is more powerful than their response. Okay? The fact that you took the initiative, the fact that you were proactive and you put them on notice is what's more powerful, because you are getting the ball rolling. Okay? You are in the driver's seat now. All right? Being the beneficiary and the trustee, right? The main trustee that's responsible for your estate. You are the one that's in the driver's seat. It's incumbent upon you to be proactive, not reactive, as to the matters that affect you and your estate. Right? But to have a foot in that argument, to have any standing in that argument, you must clear up your status first. You must declare and proclaim, you must declare and proclaim your nationality. Right? That means it needs to be able to come out your mouth and be on paper. Not then, right? But now. Not when you get ready to move, but before you get ready to move. Before you start talking about, oh, I need a trust. You should have already had these things in place. And when Moors, later, when other Moors come at you and they ask you, oh, well, can I get these documents? Can I get these writs? And kind of look at them to figure it out. Your response should be, well, where's your name and judicial proclamation? Do you have that in order? Well, no, well, I can't give this to you. This is information that's only for heirs. Okay? This is only for family members who are doing the business of the family. This is only for active trustees. Okay? But I'm making this available because it needs to be out there. It's supposed to have been out there. But we've been waiting and holding off on some things because we want to make sure that the people are not incompetent, are not retarded, all right, are not in a position where they're going to be asking a million questions instead of looking for a million answers. Okay? And Brother Nasir, I leave the floor. I yield the floor because I don't win horse.
Islam. Yeah, the importance of knowing that there's an equitable remedy, all right? Because you have remedies at law, you have remedies in equity, all right? And one of your equitable remedies is trust. And that's one of the most ancient remedies. All right? So you're going to need to know the trust law. And once you really get the trust law and really get it down, what it is, what the components are to establish a trust, and what, would be an enforceable trust, once you get those things down, now you will see how flexible a trust is. All right? Whereas though you can secure yourself, your property, your family, you'll be able to produce some form of gain, monetary gain for your family that stays in family, not taxed. All right? And you as a trustee, you have indemnity.
Indemnity.
All right?
Yeah.
You're identified.
Indemnity.
As long as you operate as a trustee. All right? Your conveyance. All right? Your motor conveyance. All right? You can, just as an idea, just to put it out there, you can, again, you're identified as a trustee. So at that point, once you have your motor conveyance, you create some form of indemnification for that as well, which they call insurance, which is a commercial term. And they really force that on the people. They force people to have to create those contracts with those companies.
Oh, and
those foreign companies.
Just to point of that part itself, not part of the interjection. When they're forcing you under these, into these insurance contracts and whatnot, realize that's a violation of under the First Amendment, because you have freedom of association. Okay, you have the freedom to associate yourself with your own people and to associate yourself with your own ways and means of taking care of business. All right, but again, going back to trust, if there's no trustee, if there's no trustees plural in place to help manage that process or that business, then it's incumbent upon you to make it work. Islam, are you on the floor? Brother Nasir?
You're breaking up.
You had? Yeah, you got it.
Oh no, you were breaking up.
All right, let me reset. Hold on. Yeah, this is a good one today. All right. We back.
Yeah, so the flexibility of the trust is vitally important, and you must be in your proper person in order to establish a trust. All right, you have the legal capacity to establish it, and you have the legal capacity to accept it.
But you had to be able to demonstrate that with your name and judicial proclamations.
There you go. There you go. And so it just shows your proof of legal capacity. All right, that's just one instance. But you can build on this, and you can, put everything into your trust, from your shoes to your cat to your dog, to your glasses you got on your face, to your bowls, your spoons, your cups, everything.
Yeah.
All right, and once it's in there, you just defend it, because you have that right. You have that right. And as far as it, a trust being registered, the only reason that you would even have to register it, because necessarily it doesn't have to be. All right. The reason that you will register it is, again, for them to backdoor you to tax you for taxing purposes.
Yeah.
All right. So, again, you have to get into the trust law, though. Really get into it and know, what validates a trust, what invalidates a trust, and your Najee, what you pointed out is as far as the allodial call schedule. All right, and you can attach that to your trust. So, all right, so if any infractions happen, to you or by you, or however, everything is right there already. It's right there and displayed for people to see. So if it's synonymous to if you're going down to one of these corporate venues and they have their call schedule, they want to get it. If you want to get a copy of something, they charge you 50 cents a copy, a note, a copy, whatever. Same instance.
Mm-hmm.
Same instance.
So you're saying with that, just to kind of reiterate for the people, if I've got a loaded call schedule and I've posted it, right, and Joe Blow off the street says, "Oh, give me your car," or whatever, right? You can have in your loaded call schedule that any theft of property from the conveyance is going to be charged at, let's say, 10 grand for the for the capture, and then let's say another 2 grand per hour for retention of the theft, the stolen property. So you're saying with an instrument like that, I could protect myself and also create a legally binding contract that would possibly create an equitable remedy for me if I was violated based on that?
Exactly. And that trust is an actual contract. It's enforceable. And it's valid.
Okay.
Right? And if anybody tries to break that or try to come in between it, there's remedy for that.
Mm-hmm. So we got a question. We got a question in the comments that says, so you have to go to their kangaroo court to receive the credit?
What credit?
Credit for what?
What are you talking? Yeah.
What do you mean?
They can get on the screen, right?
They can talk.
Free,
the floor is open.
Pop on up.
Yeah, the floor is open. You can turn your the screen and your audio open. You don't have to type it. That's part of the reason of being here, so we can be more interactive and not have to just be mystery people.
Yeah. Article 1, Section 10, that covers the credit situation as far as what credit is.
Yeah. And
being derogatory, anti-constitutional.
And two, keep in mind, we're the heirs, right? So if anything, we are the creditors, and they are the ones who are living off of our credit. So who's giving who credit right here? When you're asking questions like that.
Right.
You know what I mean?
Right.
All right. So meaning they violate.
How do you collect? They violate you.
Okay. So the collection.
Send them an invoice.
Yeah, you send them an invoice. That's how you collect.
Like,
how do they collect with you?
It's the same. Listen, Noble Jew Ali said he's going to keep these Europeans here long enough to teach us to run government.
Mm-hmm.
All right? In Article 4, Section 4 of our national constitution, the people are the government.
Mm-hmm.
You understand? And once you create your trust, you have policies and procedures. You have policies and procedures that you must enforce.
Yep.
The same way if anyone else or any other foreign corporation comes up on you, oh, sir, we have policies and procedures we have to follow here.
Exactly.
All right? And enforce it. That's it. Because you're the government.
Yep.
Just act like it. You have to have that allodial mindset. We have to have that allodial mindset collectively.
That's
thousands of miles away from home.
That's heavy right there. And I can't read it.
And there's moors out here that'll help you. It's not family helps family. Because it's at the same time, if I'm helping you, I'm helping myself. Because you have little babies, you have little children that needs to have this information.
Mm-hmm.
All right? They have to. If not, either they're going to be dead, 6 feet in the ground, or they're going to be in that prison industry complex.
Yep.
All right? And if my little boy come in contact with your little boy, all right, and he doesn't know who he is and acts as a savage, all right, then you cause injury to me.
Mm.
All right? So I'm helping you. Help us.
To raise the nation. Islam.
There you go, because government starts with family.
Woo. Come on. All right, I don't want to get too much into a tangent. I know how we can go all night.
Oh yeah, bro. Yeah.
We can go all night. We're gonna link up offline after this. It's 9:04. So with that being said, we just want to close up shop. Any last minute questions, go on and get them in the chat. But other than that, you know, we just want to say Islam to everybody. And I want to go on and close with the Moorish American prayer and show you guys I got something special that I found. You know, most temples, if you go into a temple, they'll have this up on the wall. So if you guys want to, next week, it may not be next week, it might be the week after next. But, you know, depending on what we can get lined up, it might be next week. But if not, definitely the week after next. All right. But we're going to close with the Moorish American prayer. I'm going to stand, and for all those who want to, you know, say a prayer with us, you know, 5 feet at a 45-degree angle, 90 degree, 5 on the left, 2 on the right, facing the east, and say, Allah, Father of the universe, the Father of love,
Father of the universe,
the Father of love, truth,
Father of love, truth,
peace,
peace,
freedom, and justice.
and justice.
Allah is my protector,
Allah is my protector,
my guide,
my God,
and my salvation.
and my salvation.
By night and by day,
By night and by day,
through his holy prophet, Drew Ali.
His holy prophet, Drew Ali.
Ameen.
Ameen.
Ameen. All right, Islam Moors, and if you want to get some more info, it's in the chat. Northwest Restoration Trust. Again, that's Northwest Restoration Trust. If you got any questions or comments, reach out. That's the new email. We'll put that up in the info at the bottom of this video when we get on YouTube. But let me know what y'all got. Let me cut this off for the Ustream. And, you know, we'll talk about pleadings and all of that good stuff later. But he amended his pleading. You know, he fixed what they said he had wrong about it when they said it was insufficient. So he went back and fixed it based on the amendment of the pleading, right? And it said at the next term of court, October 1855, the Dungey case was argued before a jury, right? According to Joseph Spencer's attorney, Lawrence Weldon, Abraham Lincoln's talents as a trial lawyer were evident in his argument for William Dungey. Lawrence Weldon stated that Abraham Lincoln questioned Joseph Spencer's character by demonstrating how Joseph Spencer, went from house to house, quote, quote, gabbing that William Dungey was a, quote, quote, nigger. Attorney Lawrence Weldon emphasized that Abraham Lincoln's tone and pronunciation had, quote, a curious touch of the ludicrous, which instead of detracting seemed to add to the effect, end quote. Abraham Lincoln further undermined Joseph Spencer by using humor to persuade. Now, keep in mind and peep, right? For those who are the younger generation, peep the game, peep the science, right? Keep in mind how Lincoln is making these arguments and what social issues, right? He's making a point of attacking as he's making these arguments, right? Because these are going to be very important, and these are things that happen to this very day. If you ever watch court TV or you ever, you know, sit in on a trial or anything, and you get a chance to actually hear the arguments from the attorneys, and if you're ever so lucky, you know, whatever, to see a jury trial from the, you know, from the gallery and not as a defendant, you know, or a prosecutor, you'll be able to see some things in terms of style and how people operate, you know, the strategy of the game, so to speak. And, you know, really be able to appreciate what's going on and what we're talking about here, right? So I just want to keep, you know, for those who got the eyes to see and the ears to hear, you know, I don't want to give too much. For those who don't, you know, whatever. Anyway, Abraham Lincoln further undermined Joseph Spencer by using humor to persuade the jury that there was reasonable doubt regarding William Dungey's race. The attorney, and you also want to keep in mind how other people will try to use these same tactics against you, right? The attorney, Lawrence Weldon, recalled Abraham Lincoln's statement, quote, "My client is not a Negro. Though it is a crime to be a Negro, no crime to be born with a black skin. But my client is not a Negro. His skin may not be as white as ours, but I say he is not a Negro. Though he may be a Moor, quote Abraham Lincoln. Quote, Mr. Lincoln, quote, interrupted Judge Davis, scarcely able to restrain a smile. Quote, you mean Moor, comma, not Moor? And that's Moor, M-O-O-R, comma, not M-O-O-R-E. And this, you know, how it's written, those of you in the classroom can see right here. This is where I'm at right here. Well, Your Honor, Moore, and this M-O-O-R, not Clifton H. Moore, M-O-O-R-E, right? End quote, replied Mr. Lincoln with a sweep of his long arm toward the table where Moore and I sat. Quote, I say my client may be a Moor, and this is spelled M-O-O-R, comma, but he is not a Negro. End quote. So good. All right, and we're back on the Ustream. Cool. So, all right, so going back here on page 2, Joseph Spencer's attorneys, Clifford H. Moore, Joseph Spencer's attorney, Clifford H. Moore, and Lawrence Weldon, also Europeans, filed a demurrer to Abraham Lincoln's declaration, right? Later we'll talk about what a demurrer is, but it's basically a response to a plea. It's a type of response to a pleading that you would make in a court. But you know, look that up. We'll talk about that later. Demurrer to Abraham Lincoln's declaration, asserting that his charges were insufficient in law, right? And make a mental note, you guys. Federal Rules of Civil Procedure, Rule 12, B6. All right. And just write sufficiency of claim or insufficiency of claim, and just, you know, just make a mental note right there, and we'll unpack that later in future classes, right? Judge Davis, and you guys remind me, you know, who are most interested in it, but you know, those who can't wait, go on and look it up. Agreed that 2 of Abraham Lincoln's 3 charges were faulty. The case was continued, and Abraham Lincoln was allowed to amend the declaration, right? Abraham Lincoln. You know, that was the quote from Abraham Lincoln. It says, though the account may be apocryphal, Attorney Lawrence Weldon's recollection was characteristic of Abraham Lincoln's style. Abraham Lincoln then demolished the defendant's witness's testimony. Attorneys Clifton H. Moore and Lawrence Weldon had secured several depositions from residents in Giles County, Tennessee, the Dungey family home. These witnesses stated that they had personally known the family and that the white community had regarded the Dungeys as quote, quote, Negro or of quote, quote, mixed blood. Under cross-examination, Abraham Lincoln argued that the testimony was hearsay. Pay attention. As the witnesses admitted, none of them lived within 30 miles of the William Dungey residence. So they was going off of something that they heard, right? That's what made it hearsay. Just pay attention. You know, this is touching on, like I said, this is going to touch on a lot of concepts, whole lot of concepts that you need to be kept in mind. You know, with hearsay, just keep in mind the rules of evidence, right? And the standard.